because of the limitation on the underlying healthcare provider, who only is at stake on his worst day or her worst day, is $100,000.
Even if they killed someone.
Even if they kill someone, cut limbs off, cause someone, as cases we've had, to lose an organ, require a transplant.
Babies.
Future care. We have one now where literally the baby was decapitated during the delivery, $100,000. Period, end of story is the only thing. So from a level of deterrence, I'm not sure that it effectuates any change from an underlying healthcare provider or their processes.
And that's a really interesting point, because patient safety is what this all really comes down to, right? I mean, not every bad result of medical treatment is malpractice. You know, complications do have, even with the best of care sometimes and so forth. For medical malpractice, we're talking about doing something a reasonable doctor would not do under the same or similar circumstances, but you did it. Or that they would do under the same or similar circumstances, and you didn't do that. Welcome to Bayou Justice, breaking victims, protecting power. I'm your host, Chip Wagar, a medical malpractice attorney dedicated to reforming Louisiana's healthcare laws. On this show, we dive deep into the challenges faced by patients in our state, exploring how current laws often favor institutions over individuals. Each episode will bring you compelling stories from victims, insights from legal experts, and perspectives from lawmakers. Join us as we work to shed light on these issues and push for meaningful change in the Bayou State. This is Bayou Justice, Breaking Victims and Protecting Power, a production of the Louisiana Patient Rights Advocacy Forum. And my name is Chip Wagar. I'm here today with Mike Sepcich, and we're going to talk a little bit about Louisiana's medical malpractice system, particularly in the age of COVID. Because there's some unusual twists and turns that our journey through medical malpractice has taken since 2019, 2020, hasn't it? But first, Mike, you actually began your legal career in medical malpractice on the other side, on doing defense work.
That's correct.
And you defense work with a very well-known defense lawyer, a friend of mine, Bill Bradley. When you first got into it, when you first started doing medical malpractice, what was it, what impression did it make on you? What did you find striking or unusual about Louisiana's medical malpractice system from the defense side?
Well, that's a fair question. First, thank you for having me on and giving me the opportunity to talk for something like this. I think that applaud you for the work that you and your organization is doing. It's, I think, a threshold issue for any change is to get information out, and obviously this goes a long way to doing that. As far as the impression, I was an impressionable kid. I was 21 years old when I first started working for Mr. Bradley, who is my mentor. And I think that the appeal to going to court, a lot of medical malpractice cases, particularly from the defense side, because of the limitation of liability, they're tried. And my idea of going to law school, which I had not yet entered, I was going into law school when I started with Mr. Bradley, I wanted to try cases. And my experience is a little bit different than most people, and certainly was of my colleagues in law school. I was involved in 10 to 11 trials before I graduated. Sitting second chair as a paralegal, shuffling documents, watching, preparing cases. So I certainly thought that I was ahead of the learning curve. But the interesting part of it, I guess, more than anything, overriding was, from my perspective, I'm a former athlete, I like to win. And so on the defense side, it's fairly easy to do. I was a horrible damage lawyer. We rarely would get to damages on the defense side because there's a limitation of liability. If you lose the liability
it's kind of an all or nothing thing, isn't it?
$100,000 for the underlying healthcare provider, it's gone. So you go full bore on liability. And so it taught me how to prepare. Obviously, I think just the intellectual challenge of learning the medicine. Each case is a little bit different. Allows you to play doctor. Probably all of us at some point started off in a pre-med curriculum, most of us, and then switched off to something else, me, accounting and economics. But it was a challenge to learn the medicine. I think that having sophisticated clients was also a challenge. But I was always, and everyone knew it in my law firm back where I started, I was a plaintiff in a defense lawyer suit, as always.
I'm just curious, amongst the no names we'll name here, but among your colleagues who did defense medical malpractice, just in-house, among yourselves, did you realize how rigged the game was in your favor?
You always know.
And I mean, you have to take advantage of it because you're a lawyer and you've got to do the best you can for your client. You take an oath to represent them zealously and so forth and whatever. But you did realize that it was very rigged in your favor.
100%. It doesn't take long to read a jury charge, to see the system, to understand the time that it takes a claimant to actually get to the courthouse, much less to a judgment day. You know that you are definitely on the high side. And then again, I think always when you're trying to defend as opposed to having the burden of proof, it's always easier to pick apart than it is to build.
It's easier to destroy than to create.
100%. So it certainly was inherently built in that you knew you had the advantage. And there are things that you didn't have to worry about, representing underlying healthcare providers, damages being one of them.
Right. I was going to say, when early in my career, I was a defense lawyer too, and I represented offshore drilling contractors and marine interests and so forth, crew boats, work boats, things of that nature. And the potential for astronomical injury verdicts, because the injuries were terrible. I mean, oftentimes death, brain damage, mutilation, amputation, all kinds of things, back injuries, crippling back injuries, and so on and so forth. I mean, you went into there, this is the Baccarat table at the casino. This is high stakes, and if you lose, it could be millions and millions of dollars. And that has an impact on our clients about, whether a case should be settled or not, with managing the risk and keeping it within bounds. Be better to pay a few $100,000 and take the risk of. You really don't have that in defending medical. What's the worst thing that can happen to you?
That's exactly it. I think that from a plaintiff's perspective, the reason why a lot of us maybe shy away from a case because the upside may be limited. Well, it is the positive side of that for a defendant in that, what do I have to lose? And so even in clear liability cases, a lot of times in our office, we will screen it. I'm sure you guys do the same thing. We generally don't really care what a medical review panel does because we know that where they're generally going, I think the latest statistic that we heard from the head of the PCF is that 97% of medical review panels that are in Louisiana are in favor of a physician. So think about
Saddam Hussein's last election in Iraq probably wasn't that good.
Precisely. If you really think, and that includes the so-called material issue of fact, which is really not a win for anyone. We count them as wins for plaintiff, and so do the defendants. But it is definitely stacked against a plaintiff. As a defendant, you know these things, and because of the limitation on the underlying healthcare provider, who only is at stake on his worst day or her worst day, is $100,000.
Even if they killed someone.
Even if they kill someone, cut limbs off, cause someone, as cases we've had, to lose an organ, require a transplant.
Babies.
Future care. We have one now where literally the baby was decapitated during the delivery. $100,000. Period, end of story is the only thing. So from a level of deterrence, I'm not sure that it effectuates any change from an underlying healthcare provider or their processes.
And that's a really interesting point, because patient safety is what this all really comes down to, right? I mean,
we would hope.
Not every bad result of medical treatment is malpractice. Complications do have, even with the best of care sometimes and so forth. But for medical malpractice, we're talking about doing something that another doctor, a reasonable doctor, would not do under the same or similar circumstances, but you did it. Or that they wouldn't, that they would do under
Correct.
the same or similar circumstances, and you didn't do that. So, I mean, it's a tough standard to prove for the victim and his attorney. But if you reach that point where you've established malpractice and so forth, all right, the worst thing that's going to happen is really, as an insurance company is going to pay $100,000. That's really what it boils down to. So if you're hoping that the medical malpractice system in Louisiana deters bad conduct or promotes patient safety, you'd be mistaken, wouldn't you?
100%. My experience in the defense side is not only does it not discourage, in many instances, in cases where you as a defense lawyer with your adjuster and a team of doctors who are reviewing your case and the underlying physician's care come back and have questions that do not believe that it met the standard of care. Doctors, unlike your insurance policy or my insurance policy, generally retain the right to decide whether they will consent to settle a case. Because of the system, they will refuse to do so and submit to a medical review panel, and let's see what the panel says. In light of knowing
the 97% success rate.
Because they know it. And precisely because of the situation where even though they know internally, we have questions. I have been in those meetings where we've had this case reviewed independently. We believe that your care is substandard. We think this is a case that you should consider settling. And a sophisticated client like a physician who understands the system upon which they have made the secret handshake and paid the fees and now they're part of, say, I will not do that. I'm going to go through the medical review panel and hopefully 3 of my colleagues will find something to exonerate my behavior. And 97% of the time, they do. They're correct.
Okay, so you're defending this case. You know the doctor has been judged by his colleagues to have committed malpractice. But the panel not wanting to, knowing that this doctor may be on their panel, in another month or so. It's not an anonymous system, is it?
It is not.
So they come back with a verdict. They're in the 97%, and they come back with a verdict that there's no malpractice here, nothing to see. Move along. Okay, so now you've got this case. What does that do for you? That panel opinion, that written panel opinion, and those 3 medical doctors. What does that do for you when you're defending?
Well, it gives you a piece of evidence by the Louisiana legislature that I can shop around and stand up and grandstand in front of a judge and a jury that says that despite the allegations made, 3 physicians in the community looked at the care and found no wrongdoing. And by Louisiana law, it comes in as a piece of evidence. It also gives you, as a defendant, 3 built-in experts, where I don't have to go out to try to find an independent expert. I can bury the independent expert who gave us an internal review before we went to the medical review panel and call one of the colleagues who
that's secret. No one can get that opinion, can they?
Precisely.
And so you've got this now that written opinion, that panel opinion, where they find no malpractice here. You could that would be hearsay normally in the rules of evidence. That would be hearsay. You couldn't. But that's admissible as evidence because of Louisiana's medical malpractice. That is by statute admissible evidence, even though under the laws of evidence that would be hearsay.
Correct. In any other venue or any other area of law, that piece of paper, similar to a police report,
it's hearsay,
would be seen as hearsay. Precisely.
Okay.
But the Louisiana Medical Malpractice Act says it is admissible as evidence in a medical malpractice case, and it gives a defendant an instant defense and instant 3 experts to go out and hire and call to defend the opinion.
And 90-some% of the time, it's in your favor.
It is in the defendant's favor.
And let me ask you, back in the day when you were doing these cases, not necessarily you, but you or your colleagues, did you ever blow one of those things up real big on a poster board and put it on the easel in front of the jury while you're making your opening statement or your closing argument?
It's Exhibit 1. It's shown from the moment we step in and introduce ourselves. And if a judge allows us to show any sort of demonstratives during voir dire, it's up 110%.
And kind of gives the jury the idea in their heads, doesn't it, that, whoa, 3 doctors looked at this. I mean, I'm not a doctor. What do I know about this, right?
So what it does is it gives instant credibility, and I believe it's faulty credibility, but it gives instant credibility of the defendant physicians and the healthcare providers to a jury, that before I even ask you, we have to do this now, but before you even got involved, this has already been reviewed by 3 people who do this type of work, and this is what they said. And so it goes back a little bit to what we talked about before. It's a lot easier to take it down than it is to build it up, and they've already built their house off of a rigged system, off of a system that finds against victims of malpractice 97% of the time.
But that's not the only bad thing about the medical review panel system, is it? It takes a long time, a lot of times, to get through it, doesn't it?
So in the same statistic that I gave you, the 97%, the same CLE with the head of the PCF, the average, this was in 2024, the average life cycle of a medical malpractice claim from filing to dispensation, which would be in a case either through settlement or judgment, is 5.6 years.
5.6 years. And this for a catastrophically injured victim or family who's lost a loved one to death or whatever. So half of them take longer than that.
I was going to say, I'm sure in your file cabinet, unfortunately, if you have a issue that may need, some supervision from an appellate court with a discovery issue or what have you, and it goes up and then comes back down. We talked initially about COVID, the right to access to courts was very, very limited with jurors and all. It was almost a 3-year timeout period. So it is not uncommon for a medical malpractice case to be tried 8, 9, 10 years after filing. And it puts a victim very much at a disadvantage to go in and talk about something that occurred 10 years ago. Life does go on, but you're trying to go back to, I missed this person, this is what's happened to my life. Now, sometimes I guess it could help you prove your case because this is how it's impacted me, and we have certainly a number of those instances. But 9 times out of 10, jurors are looking at you. Why did it take you so long to get here? Because they do not understand the inherent delays that are built into this system.
Over the years, while you're working your way through the medical review panel system, and then you get into the court system, which has its own delays, and can take a year or 2 or more to get to trial if that's where it's going. Over the course of that period of time, you have contact with your clients, the victims. You talk to them, I suppose, about what's going on in the case. They maybe have to answer interrogatories, written questions that they have to answer, and work on those with them. They might have to give a sworn deposition and be subjected to questioning, even though they were asleep at the time the negligence happened, or the loved one died, and so on and so forth, and so forth. And then maybe as we get closer to trial, trial preparation. All those times that you talk to the victim brings up memories, doesn't it?
It's like picking a scab. Every single time they have to relive it. We have instances where they've designated a family member in a loss of a family member, which resulted in the malpractice and then the claim being filed. We have a number of cases in our office where they've designated a family member because mom, dad, daughter can't simply go through it every single time. And so it's difficult. It's difficult to have those conversations because usually it's one of their worst days in their life, and they relive it over and over and over and over again. And the system lends itself to that because it takes so long.
There's no closure early on is there?
Cannot be until the final dispensation of the lawsuit, and that's not necessarily the case through the panel process, because really now we're just starting. You go through 2 years, usually 18 months to 2 years in a medical review panel proceeding.
And by the way, we should probably mention, because a lot of viewers might not understand this, a 97% no negligence, no malpractice verdict, that doesn't stop you. You can still go ahead, and we do all the time. I can't tell you how many millions and millions and millions of dollars I've recovered in cases in which there was a 3-zip panel opinion against us, and I'm sure you could say the same thing. Almost every one, I think, is
I
like
think
that.
The classic example of the attention that our office pays attention to the medical review panel, we have a catastrophic case with a 21-year-old who admitted to a local hospital and spent 724 days in the hospital. Multiple acts of malpractice. The director of the medical facility said to settle the case. We had a 7-figure settlement on the table as we were going to the medical review panel, and a co-defendant was holding out. So we went through the panel process. One of the defendants, 135,000 pages of medical records, 50-page submissions of evidence to the panel, which the statute, as you know, requires and asks us to do. We fully participate in. We know that there is acts of malpractice. We have admissions from defendants and all. We do a 52-page submission, and literally 15 minutes after the panel convened, they found no malpractice. One of the defendants did nothing more than submit a flash drive of the medical evidence. Didn't even
bother to say anything.
Just, guys, save me like you always do 97% of the time. And they did. That's the system that victims
But you
have.
can go on and file your lawsuit after that anyway. But it is an important piece of evidence, as we've talked about. They can put that on the poster board. They can talk about it. They can call one of the panelists or more to be an expert witness. So it's not inconsequential, but it doesn't stop
Correct.
the process. Okay. So we have the burden of proof, as we call it in our business. We have to show that what the standard of care was in this particular case, that the standard was violated by the doctor or nurse or whoever it is, and that caused or contributed to the injuries and damages that occurred to our client.
Correct.
Right? And that's a tough thing, because you have to have a medical expert of your own, right, to
Correct.
do that.
Without it, you won't
even get there.
Particularly, I guess, embedded in this panel process, and the defendants, as the defense lawyer, the routine, very simple. Take the case to the panel, win the panel, take the panel opinion, and file a summary proceeding to get the case thrown out if it is filed.
And you did that many times, I'm sure.
It was done on
routine,
on auto. We do it on a routine basis, and it requires the victim to come in with a qualified medical professional who's willing to sign an affidavit to say that there was a breach or violation here in what should have been the appropriate care of this patient. Without it, all of those things we just talked about, you don't even get your day in court.
Now, in 2019, we had a little epidemic in this country, a pandemic, actually. 2019, 2020, and then Governor Edwards declared a state of emergency in Louisiana, which triggered the Louisiana emergency, forgot all the LEPA,
Correct.
This emergency statute that actually had been created decades before, after Hurricane Katrina. And it was meant to do a lot of things, but among other things to protect first responders from negligence claims when they're working under dire conditions, like in a hurricane, in the aftermath of a hurricane. And, the state of emergency would be for a few weeks, a few months, maybe Katrina might have been more, a few months, but But in this case, with the COVID pandemic, the statute was triggered by the Emergency Act, and it lasted for 2 years, didn't it?
2 years and a week, I believe. I think from March 12th or 13th of 2020 until March 26th or something like that of 2022. And as I understand it, and back in my defense days, I represented a facility in a civil litigation at Baptist Hospital, which Dr. Poe was involved in, life care, hospice facility, a hospital within a hospital. Part of this emergency proclamation and Good Samaritan gross negligence standard that we're about to talk about, I believe, came about as a result of Katrina. And I get the intent is to have healthcare providers willing to step up in extraordinary circumstances when perhaps instead of taking that on call to be stuck in a hospital with Katrina for a number of days without power under very difficult circumstances, to have healthcare providers to do that and provide them with, I guess, an increased immunity almost. It's almost an immunity statute. But what it says is that you cannot be found liable or, malpractice claim against you unless you were grossly negligent. And it's brought about a lot of different things in Louisiana on top of the act because of how long it lasted. And our going, again, as they did with the cap, in my opinion, don't even attenuate it to the actual event. So we have issues where gross negligence is the standard, and the care had absolutely nothing to do with COVID at all.
And I think I want to talk to you about a particular case that I know you're involved with. But before I do, what is gross negligence? How is it defined? Or is it defined? Or
it's vaguely defined. It's not defined by the legislature. It was defined in, I believe, a Supreme Court case after Katrina. And it's somewhere, I guess the best way to describe it as I understand it, somewhere between negligence and intentional tort. So somewhere in this vague area, it just can't be mere negligence, but it almost close to willful conduct, I believe, and it's a bunch of different legal terms that they
somewhere
utilize.
Between the 20-yard line on one side and the 20-yard line on the other. Somewhere in that area is gross negligence, and nobody really, there's no firm definition of it, is there?
In a code state, we don't have a code article that defines it. That much we know. It is this nebulous somewhere in between negligence and intent.
But the idea is to make it more difficult. However difficult Louisiana's Medical Malpractice Act is and has been, this would make it more difficult.
Correct.
And so the thing about it is, I think that makes it because I practice in Texas as well. In Texas, there's very strict parameters that it has to be the defense. It's an affirmative defense. It is a defense, but you have to prove that the circumstances where the malpractice occurred was due to COVID in some way. In other words, you're in an emergency room that's packed with 100 patients and you can only see 20 of them at a time, and someone dies in the hallway and so forth. That kind of thing. So they do have it, but it's very. You have to show that it's related in some way to the pandemic. It's not if you're doing cosmetic surgery, down the street and so forth, and something goes wrong, and blah 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 blah. That's not connected to COVID or anything. How does Louisiana deal with that issue?
Like it does with the cap. I believe there are 26 states that have or that had some sort of immunity heightened requirement, statute and or law that was dealing with COVID and COVID related cases. They all require some connection to COVID.
But Louisiana, except one.
Exactly. Guess which one? Louisiana does not. And it has been a very, very difficult thing to do when you have people who come in with ordinary negligence claims that have absolutely nothing to do with COVID. The care, none of it had to do with COVID. Their access to doctors, had nothing to do with COVID. The treatment regimen had nothing to do with COVID. And you have to look them in the eye on their worst day in a catastrophic case. I don't think that we can prove this heightened standard that the legislature now requires, because your malpractice that caused your damages happened during a period of time that had no real effect on you other than to give the doctor a pass.
So during this 2-year period, let's just say, you have elective surgery for back pain, a herniated disc, or you have a stent put in because you're having chest pains and so on and so forth, and you have a need for it. Or you have any other kind of elective surgery or even emergency surgery for something, and something goes wrong and the patient dies or is permanently, catastrophically injured and crippled for the rest of their lives, you have to prove gross negligence.
Correct. And we have had many cases in our office that have come in through this period of time where we did not feel, or you could not get an expert to say what is gross negligence or how you prove gross negligence, because they don't know the standard, and until they sign an affidavit, you can't support that case.
I have talked to, of course we face this as well, and it's an interesting conversation that you have with a consulting doctor who's not from Louisiana. A lot of times they're virtually always out of state, because no Louisiana doctor, very few Louisiana doctors will testify against another Louisiana doctor. But so we have this conversation with them, and one of the remarks I always thought was very telling is that I remember this one doctor said, okay, but this guy's life was in danger. This guy's life is on the line. If you get this wrong, if you don't follow the protocols, if you commit malpractice, he dies. His life is on the line. And they didn't do that. And he died. To me, that's gross negligence. When someone's life is on the line, or permanent paralysis or brain damage and so forth, frankly, almost all of our cases involve gross negligence, really, when you get down to it, because the stakes are so high. But that's not how the courts look at it, is it?
It does not. And the one that pulls at my heartstring that came through our office during this time, and it's a case that we're actively battling.
Tell us about that one.
It's a 6-year-old little girl who was having some seizures and started throughout 4 months or so before seeing this neurologist, and put her on a regimen of medicine that didn't necessarily pan out, and then switched her medicine. But at a point in time, never ordered a blood test to assess how her organs were handling this, particularly her liver.
I know how this story's going to end. It's not good, is it?
It's not. Black box on the hepatotoxicity of the medicine, and that it should be closely monitored. And literally 4.5 months, not even 4.5 months, I want to say about 4 months, 4 to 6 months in, she becomes jaundiced, falling asleep at school. 3 different ER visits. They finally figure out that she has a genetic disorder that makes her susceptible to this medicine. And fast forward a few months, she requires a liver transplantation. Probably will require another one in her lifetime, is on anti-rejection drugs, months in the hospital. I think I keep in touch with the family. We're now up to surgery 31 or 32. It's a gross negligence case. And the best part about it, in the sense from a legal standpoint, is when we deposed the defendant physician and asked her point blank, what did this case have to do with COVID? Her answer under oath was nothing. Did you treat her any differently? No. Would your care have been any different in 2017, 2018, 2019? No. Would it have been different after COVID? No. So it had nothing to do with COVID. Nothing to do with COVID. I would have treated her the same way today as I did then. That case is a gross negligence standard, which of course that is the way they're defending this case.
And if it was in Texas, this wouldn't be a gross negligence case because, again, no relationship. If it was in Mississippi, I happen to know no relationship to COVID, no gross negligence is needed.
As I mentioned before, I think there are 26 states that have COVID-related laws. Only one says that that's a gross negligence case when it's not related to COVID, and that's Louisiana, which is the state she's in. All of the other 25, it would not be a gross negligence standard.
Now, I happen to have gone to the legislature when this was going on with some of our colleagues to bring testimony before the Senate committee that considers malpractice bills to change this so that you had, like Texas or like Mississippi, you have to show some connection to it. It didn't happen. It didn't happen. There are, according to the Secretary of State, over 80 lobbyists in Baton Rouge roaming the halls up there that lobby for the healthcare industry, and none for patients' advocacy. Not until now, that is, which brings me to you and your firm are into this and are supporting the Patient Rights Advocacy Forum. What would you like people to know? What would you like people to do something about the terrible injustice that Louisiana's medical malpractice system imposes on the most vulnerable, catastrophically injured people?
Well, I think it starts, honestly, Chip, with discussions like this, and I think information is power. It amazes me how few people know. They may know that we have some sort of cap. They have no idea how onerous it is. They have no idea how onerous the system is. They have no idea how long it takes and the burden that a plaintiff has to get to court, much less, actually prevail in court. I recently had in our office a former state senator came by. His mother had an instance that he thought may not have been necessarily the best care, and we reviewed the case. Has a number of brothers and sisters, and when we explained to him, well, if you have a case or not, this is basically the playing field, he was dumbfounded because he was under the impression, there's a state senator who voted on laws in our state, that it was a per claimant situation, not that, no, sir, $500,000, $100,000 from the underlying, $400,000 in addition from the state fund for all of you on our best day. And so I think
that's as good as it gets.
That's exactly it. So I think it starts with information and getting it out, because I do think that a lot of folks don't understand it, and always it's the same thing until it happens to them. But as far as from a legislator's standpoint, and I know we're certainly in a very conservative state where tort reform and additional tort reform is probably something that we're all going to be facing. It seems like it's every year. This is an antiquated law. It hasn't been touched in 50 years affirmatively. It is not kept up even with the onerous statute that it was modeled after. And I recognize that you have 80 lobbyists and everything else, but the people who put you there are the victims that are affected by these things. And I have yet to meet anybody who, doctors included, who are satisfied with the system of healthcare that we have here in the state. Part of that is because there's simply no repercussions, no accountability for those mistakes, because from a business decision, and I sat on the other side of that as a defense lawyer, $100,000 is an outpatient care service now. It's nothing. If you look at where the statute is in recovery compared to where costs have gone, it's 3-4 to 1. We'll just take that increase in allowing victims to recover what should be something that, if on a catastrophic injury, much, much more than $500,000. And I think it needs to be looked at. And I don't think that it has ever been truly, truly, truly examined other than just to defend it. And I think at some point we have to take a look at it and say, are we really doing justice to the people of the state of Louisiana? This is fundamentally unfair.
Well, Mike, I want to thank you for coming by and sharing your experience with medical malpractice with us. It means a lot to those of us and yourself. I know you and your firm have been behind this 100%. And we got a lot of work, ahead of us, but I think that we're making a great start. The playing field was zero before we came along, and we're going to be there, and we're going to do something about this. Whether we win or lose, we shall see. But I feel the righteousness of our cause is our greatest weapon. And as you say, getting the information out to legislators and to the general public of how draconian and how terrible the Louisiana medical malpractice system is. We have less rights here in Louisiana. If you're a victim of medical malpractice, we have less rights than people in any other state in the union. Is there something about us that we deserve this? Is there something, about Louisiana that we deserve less than anybody else? Ask your legislator when you get a chance about that. So if you would like to learn more about the medical malpractice system in Louisiana and how it may affect you before it does, visit our website at patientrightsla.com and contact us. There's a page, tell us your story, sign up, join us, and join our cause. We need you when the time comes. We need people to contact their legislators. There's a whole page on our website that will help you contact your legislator, your senator, your representative, and it's organized by where you live. So a lot of people don't know, who their legislator is or their senator. You don't have to. You can go on there and look where you live, and it'll immediately take you, and you'll be able to easily write an email and contact your legislator and tell them it's time. It's time to change. Thank you for watching. Thank you for listening to Bayou Justice. I hope today's episode has given you valuable insights into the complexities of medical malpractice in Louisiana. If you'd like to learn more about our mission or get involved in our advocacy efforts, please visit patientrightsla.com. Your support can make a real difference in the lives of patients across our state. Remember, together we can create a fairer, more just healthcare system for all Louisianians. This is Chip Wagar, and I'll see you next time on Bayou Justice.